A very good afternoon, ladies and gentlemen. Thank you for tuning in. I hope you are all having a pleasant day. It's great to be back again this week with another episode of the Strata Talk Show. With that, I would like to welcome everyone to the 44th episode of the Strata Talk Show, brought to you by the Excel Academy of Real Estate. In this talk show, in case you're new, we'll be discussing issues and cases related to the management of stratified developments with various industry professionals. Joining us today, we have Mr. Leong Chee Weng, who is a partner of Chu Co, to speak on the topic of the unseen risk of property, understanding latent and patent defects. If you have any questions for Mr. Leong, feel free to leave them in the comment section below, which will be addressed in the Q&A section at the end of this talk show. Without further ado, join me at welcoming Mr. Leong. Welcome, sir.
Hi. Thanks, Naufa, for the introduction. First of all, I'd like to thank Excel Academy for having me on the show again. This time to share on a topic of defects, which I think most of us can relate. Of course, most of you is going to be a home buyer or is in fact a home buyer. So as a home buyer, you have problem with your house. You face leakages, painting coming off. So you may want to know, as a home buyer, if I'm facing all these issues, how do I deal with it? Do you fork up your own money to fix it? Can you claim claim against someone for the cost to do it? And if you can claim, who do you claim and how do you claim? So these are the few topics that I would like to aim to address today. Without further ado, I'm going to move on. Now, these are the topics that I'm going to try to cover. There's quite a lot of that. Just in summary, first of all, we're going to cover what is defects. You heard it a lot. You even heard of patent defects, latent defects. But what exactly is defects? What exactly is patent defect, latent defect, and why is there a need to distinguish between patent defects and latent defects, which is the main focus of the topic today. And then, of course, in the second part, we're going to go into who is responsible to rectify these defects. As a home buyer, you want to know who can you claim against. Do you claim against the developer, or do you claim against the contractor, or even your neighbor? And for those of you who are staying in a condominium, you even have a additional party to consider. Is it your joint management board or what you call the management corporation? The body who is running your condominium. And then, of course, on the third part, we're going to go into is how do you claim? How do you initiate a claim against the relevant party? What is the proper forum? Is court the only way? And then lastly, we're going to go into the time limitation for you to bring a claim. Is there a time limit for you to do so? What happens if, especially when it comes to defects, you only found out about a particular defects at a very late stage. You've taken the property and you did not know about the defects, and then suddenly the defects only arise out of nowhere. Are you then prevented from bringing an action? So these are the four main areas that we're going to try to cover today. Now, moving to the first part, what is defects? Is there a definition to it? Well, there have been cases who try to define, but as you will see, this is one of the many examples, which says that it's any deficiency in the design or construction of a building or structure, resulting the construction failing to perform as required by applicable contract or reasonable standards. Well, this is a more fancy and more legal way in one define defects. But to put it simply, and to all the laymen out there, essentially it is something that is faulty or something that is not built correctly. Something yang rosak or tak betul. And it is based on reasonable standards and not based on our own preference. So for example, if you got a house and you don't like the color of the wall, that's not a defect. Or if you've got a house and it comes with a window and the window is not the best brand that you get, that is not a defect. Defects is essentially where something is not working. For example, the door cannot close properly. So these are what we call defects, and it's by a reasonable standard. But in law, the law actually draws distinction on two types of defects, which is patent defects and latent defects. Now you may ask, what's the difference? Between what is patent defects, what is latent defects. We'll go through that in a bit. But first of all, you may want to know, why does the law want to draw this distinction between patent and latent defects? Well, first of all, because the court treats defects differently. If it's patent defects, there is certain treatment to it. If it's latent defects, the law treats it differently as well. And especially, for example, when it comes to timeline to sue, like I said, what happened if you only found out about the defects at the later stage? So the court actually treat these type of defects differently. And also because of the term of what we call a defects liability period. As a home buyer, it's very common for us to have what we call a DLP clause. So this is a typical DLP clause. What is DLP? Essentially, in a nutshell, is once you have taken possession of a property, you have 24 months to raise any defects that you can find with the developer. This is a common clause which you'll find from the contract you enter into with the developer if you're buying a new house. So this is a common. So what will happen is, in that 24 months, if you identify any defects, you have to notify the developer, and the developer will have to rectify those defects. Now then the question is, what happens if the defects cannot be detected within that 24 months? Or if the defects only arise out of these 24 months? What happens? Can you still claim against the developer under this clause? We will deal with that later. But for now, I just want to let you all know that you have this clause in your Schedule H and Schedule G dealing with defects liability. Now, going to what is patent defect. Now, the English phrase of Sanderson against National Coal Board have tried to define, which says that a patent defect is not latent when there is no one to observe it. The natural meaning of the word patent is objective, not subjective. It means observable and not observed. Well, of course, for some of you, maybe this is a handful, it's very legalistic, very technical. Let me simplify it for you. Essentially, patent defects, right, are defects which are obvious, which is something that you can discover from reasonable inspection or something you can see with your naked eye. So for example, if you go into the house and the paintings are coming off, and the door handle is not there. So these are something that you can identify, you can see. So this is what you call patent, or what we call obvious defects. Now, what this case is of Sanderson and National Coal is trying to say is, just because, right, the defects is there and you didn't see it, doesn't make that not a patent defect. Meaning to say, if you have a defect at some corner of your house, which if you walk through that part of the house and if you look at that part of the house, you can identify the defects. But for some reason, you have stayed there for 24 months, you stayed there for 3 years, 4 years, you don't go to that part of the house for whatever reason, feng shui reason or whatever, you don't go to that part of the house. So, and then after, many years, someone went into that house and you saw, hey, actually there's a defect. That doesn't mean that is not patent defects. That is still patent defects because it is a defect that at any time if you go to that area, you can identify it. So that is the difference between latent defect. Latent defects, which I'm going to go into later, is defects which you cannot see with your naked eye. So which is why this case is saying the question is observable, not observed, is whether you can observe it. Just because it is not observed, just because you didn't see it, because you chose not to go to that part of the house or whatever, it doesn't make the defects a non-patent. It is still a patent defect. So these are some examples of what are patent defects. Cracks on the wall, loose floorboards, unusable fixture. These are things that you can see. Clearly when you go into the house, that's the first thing you see, stains and all this. So these are patent defects. Now, what is latent defects? Latent defects is, as defined by the case of Maxwell and Shirt, it's a concealed flaw, a defect that would not be discovered following the nature of inspection that the defendant might reasonably anticipate the articles will be subjected to. Essentially, it is a defect which you cannot see with the naked eye. It is hidden, and it cannot be detected even by reasonable means. So what are these examples of latent defects? For example, your improper design, poor workmanship, and the most common one is defective waterproofing when you have leakages. Because as you appreciate, some of your plumbing work, your electrical work, these are all hidden behind walls or hidden in the ceiling. So even if there's some leakages from plumbing or the waterproofing is not being done well, you have problem, but the problem may not arise immediately. It might be over time, where the leakages are small. It might come over time. It's not something that you can see with naked eye, but over time, the defect is going to get worse or it's going to get more obvious. Then only you can detect this sort of defects. So those are what you call a latent defects. Now, the Malaysian case of Sigma Elevator has sought to try to also shed some light on the distinction between patent defects and latent defects. So this case involves Sigma Elevator. Maybe some of you might know, who's a specialist in elevator and escalator. So in this case, there was some allegation of defects, on an escalator that was being built by Sigma Elevator. They're saying that there's defects to step rollers and some step chain rollers. I tried to Google it a bit. Step rollers essentially is your wheel who is that is installed in your escalator. Of course, there's another part of the defects as well, where it involves that the landing of the escalator is not on the same surface as the land. So meaning to say that to go on the escalator, there is a step. And then they're saying the developer is saying that because of that, it causes danger, and that itself is the defects. So why, in this case, the court discussed the difference between patent and latent defects? Because here the contractor is trying to argue that, look, these are patent defects, meaning something you can see with your naked eye. Therefore, you should have raised it during the defects liability period. As I've shown you, defects liability period is the period where, during a specific set of time, it may be 12 months, 24 months. If there's any defects, you should bring it to my attention and I will fix it for you. So the contractor here said, well, that is something that you should have done. You should have raised it to me during the defects liability period. And since you didn't, so I'm not going to rectify it. Of course, the other side, the employer is saying, no, this is not a patent defect. It's not something that I can identify immediately, because they are trying to say that the whole reason why the cause of the defects is because of manufacturing problem of the step rollers and step chain rollers. They're saying because it's manufacturing problem, it's not something that I can see with my naked eye. And these step rollers are actually part of the escalator. It's something that is installed in the escalator, so it's not something that you can see with naked eye. That's what the employer is trying to say. So the court here actually disagreed, and they said that no, this is something that it's clear that it's a patent defects, and eventually found contractors. So before I move on to the next topic, you may want to ask, okay, then how do I know whether it's a latent or patent defects? What do I consider? Well, like I said, I think the key consideration here is whether the defects is something that you can identify from reasonable inspection. Of course, to put it simply, it's just whether you can see with naked eye, but that's quite a more simplistic term of trying to say what is patent defect, because patent defect also go further to say that you need to also it also include defects which, if you do a reasonable inspection, even by skilled individual, meaning if your architect or engineer go there and if they just do a very simple inspection, it would have been identified, that would still be patent defects. So, and the test here is an objective test, means objectively, if someone were to go in and to do a simple check, would they have been able to identify the defects? And if the answer is yes, then it is more likely that it's going to be a patent defect as opposed to a latent defect. Now, imagine a situation where you're a home buyer, okay, and you bought a house and you stayed in the house for a few years, and out of nowhere you found out there's some defects, there's some leakages. So then you want to know, okay, who can you claim against? Or do you have to actually fork out your own money and try to get someone to go and rectify it? That would be important to you as a home buyer, I would presume. So this is a typical relationship that you can see. Of course, you have, first of all, between the home buyer and the developer, where you buy the house from the developer. You also have a relationship between the developer and the contractor. So before selling to you, developer would engage a contractor to actually construct the entire building or the property. Now, for those of you who is familiar with the concept of privity of contract, just because the contractor is building this property and the end user is ultimately the home buyer, this doesn't mean that there is a contractual relationship between the contractor and the home buyer, because contract is quite separate. You need to have a formal contract entered into between you and the contractor in order for there to be a contractual relationship. Of course, under the law, besides contractual relationship, you have other relationships as well. But that's just for your information. And then, of course, you have between home buyer and neighbors. Under the law, as a neighbor, you owe a duty of care to your fellow neighbors. And that duty includes, not causing any damage, not causing any nuisance to your neighbors. And for those of you who are staying in a condominium, as I've mentioned, you have your joint management body or management corporation to help you manage the common area of your property. So under the law, arguably, you can go after as a home buyer, you can go after the neighbors, JMB, developer, and contractor. Sometimes you can go after them, all of them. Sometimes you can only go after some of them. So then the question is, who do you know who to go after? Now, first, then you have to look at the relationship between the home buyer and the developer. Typically, the relationship will be contractual, where you sign what you call a Schedule H or Schedule G contract. And then if there's any defects, arguably it's the responsibility of the developer, especially when you have the DLP clause, which I've shown you earlier. And in order to claim under the SPA, there is actually a agreed procedure under your defect liability clause. So under between the home buyer and developer, if the defects is a patent defects that appears during the defect liability period, developer will be responsible. If it's latent defect after DLP, developer will be responsible. And if it's recurring defects after DLP, the developer will be responsible as well. Now, in order to claim against the developer, there is actually an agreed process in which you have to claim against the developer for any defects that arise during your defects liability period. So I briefly summarize it. Essentially, it requires during the defect liability period, which is the 24 months, if you find out any defects, you have to quickly give notice to the developer, a written notice. You have the right to say, hey, look, this is the problem, this is the problem. And then the developer must rectify the defects within 30 days. If the developer does not do it, then as a home buyer, what you then need to do is to give notice to the developer to say, look, it is going to cost me X amount to go and do it. So please, I'm giving you another 30 days to go and do it. And step 4, if the developer, despite being notified of the cost to repair, still refuse to repair or fail to repair, then you as home buyer, you can engage someone to go and do it. Of course, who you engage must be the same person who's given you the quotation, and the amount that you are going to be able to claim should be the same amount as the amount of the quote that you have given to the developer. So if once you have done that, once you have appointed someone to go and do it, and you have incurred the cost, then you can claim from the developer the cost that you have incurred to rectify the defects. Now, moving on to the next type of relationship, which is between you as a home buyer with the neighbor and your joint management board, JMB and your MC. And under the law, your relationship is actually governed by the Strata Management Act. Or, like I said, under the common law of negligence, where you owe a duty of care, or they owe you a duty of care. So for the joint management, JMB and the MC, they have a duty under the Strata Management Act to rectify defects, but it is only defects in relation to common property. Now you may ask me, what is common property? It's defined here under the Strata Management Act, but it's a bit legalistic. I've put it on the screen. Essentially, one of the key considerations is parcel of the land which is not being used by you alone. It's being used by other owners as well, which is why it's called common property. So, so example of your common property will be the car parks, any parks that you have, any driveway, lifts. These are not just being enjoyed by you, but it's being enjoyed by other occupants, by other owner as well. So JMB has obligation under Strata Management Act to rectify any defects that arises from all this common property. Now, when it comes to defects dealing with JMB, MC, and your neighbors, one of the more common defects is interfloor leakages, when you have leakages from your roof. And the difficulties that you may face is you don't know who caused it, so you don't know who to bring. Do you sue your neighbors? Do you sue the JMB? Or do you sue the developer? In fact, just to share some of our personal experience, recently we just did a matter where a neighbor was trying to claim against our client for interfloor leakages. And the neighbor actually brought our client to the Strata Management Tribunal, which I'm going to take you guys through as well. So that is quite a common occurrence. Now, under the Strata Management Act, there is in fact a process to deal with situations where you're not sure on who is the cause of defects and who, as a home buyer, who can you take action against. So under the Strata Management Act, there is actually a procedure, a process, which I've highlighted on the screen. What you need to do is, first you need to give a notice. So as an affected home buyer, you need to give a notice to the JMB or the MC. And upon receipt of the notice, the JMB and MC has an obligation to conduct an inspection at your property. Of course, as a homeowner, you need to give reasonable cooperation as well. You need to give them access to your house. So they will go in, they will do a joint inspection, and they will try to identify what is the cause of the leakages or what is the cause of the whatever defects that you're facing. So then, after the inspection, the JMB and the MC will issue a certificate or issue a document to identify who is the party who is responsible to rectify it. And whoever the JMB or MC determine is responsible to rectify, the person must rectify it within 7 days. So for example, in our case, what happened was the JMB and the MC actually issue a certificate which says that my client is obliged to rectify the defects because my client is the one that caused the defects. Of course, if you don't agree with the JMB's finding, there is another process where you can challenge that decision. But the point is, once the JMB have decided, look, it is you or you who is responsible, you have to do it. And if you don't do it, what will happen is the JMB is supposed to step in and to do it and to claim against the party who is responsible. Now, you may then ask me, well, okay, it seems like there's so many people I can sue. I can go after the developer, I can go after the JMB, I can go after my neighbors, and sometimes maybe even the contractors. So then, who do I choose? So these are some of the considerations that you may want to think about when you are thinking of bringing a claim for defects. First of all, you need to find out who caused the defects. If it's the defects that is caused by you, then of course it's quite difficult for you to then claim against someone else. So you first of all, it may be beneficial for you to find out who actually caused the defect. Second is, where do the defects arise? Is it in your house or is it in common area? Like I said, if it's in common area, usually the obligation is on the joint management body or the management corporation to go and rectify it. If it's in your house, most likely it's either the developer, your neighbor, or even contractors. And the next question you need to consider, who is responsible to rectify these defects? So it's quite similar. It depends on which area and depend on whether you have any agreement, whether it's caused by who. And then the fourth one is, who is financially stronger? Now, you may have a situation where you can claim against multiple parties. But even if you have claims, for example, your neighbor, but even your neighbor is not making much, there's not much point in bringing your neighbor to court or whatever if you know that they're not going to be able to pay you. So are you better off perhaps if you have the option to go after developers who are more financially strong? So these are something that you may consider as well in terms of who you want to bring to who you want to claim against for your defects. Of course, then the question is also, when did the defects arose? Is it before or after DLP? Is it patent or latent defects? Because depending on this, you may want to see then whether you still have a right to go after the developer for patent defects under your contract if it appear after DLP. So these are some of the factors that you may want to consider in determining, okay, who should I go after if I have, if I'm facing some defects issue. Now, as a home buyer, what are your options? You can go after various parties based on the factors I've just highlighted. Then the next question you may have as a home buyer is, okay, then how do I do it? How do I claim against these people? Is court the only way? Well, the answer is no. As a home buyer, you actually have a few options. Court, of course, is one of it. Of course, you also have what we call a home buyer tribunal claim under the HDA, which is the Housing Development Act. You also have the Strata Management Tribunal claim under the Strata Management Act. I'm going to take you guys through each of all, for at least for you all to consider. In the event that you're really facing this issue, what would be the proper forum for you to bring your claim? Now, the first one that I want to touch into is the home buyer tribunal claim. There are certain factors that you should consider in terms of choosing your forums. As far as the tribunal house buyer claims is concerned, it only can hear a claim amount not exceeding 50,000. So if your defects that you want to claim causes you more than 50,000 to rectify, housing tribunal is not the proper forum for you. And it must be based on the cause of action arising out of your SPA, which is a sale and purchase agreement with the developer. So it must be something within the SPA. So it doesn't just confine to your defects. It also includes any of your LED claim, whatever that's in your agreement with the developer. And there's also a requirement and that any claims you want to bring against the developer under the Home Buyer Tribunal, you must be done within 12 months from either the expiry of the DLP, the issuance of CCC, which is a Certificate of Completion and Compliance, or the termination of the SPA. So there is a time limit that the Act sets on when you can claim against the developer. And typically what you can claim, I've set up here, is when you have a defects in workmanship, defective material, and where the property you bought from the developer is not constructed in accordance with the plan. And of course, you have a LAD then which leads to a late delivery of VP and all this. So these are the claims that you can bring to the Home Buyer Tribunal. And from what I've checked, I think the last time I've checked, it only costs about 10 ringgit to file a claim from the Home Buyer Tribunal. An award will be given quite quickly, which is the rule says that you have to give an award, meaning the tribunal, the person who hear your claim, have to give a decision within 60 days from the first day of hearing. So that's your Home Buyer Tribunal claim. This is just briefly a summary of the procedure. First, as a claimant, you have to file your statement of claim, and then you have to serve it on the respondent, which usually is a developer. And then the developer will then have 14 days to file their reply, the defense, and then you after that you can file a reply to the developer's defense. Then there will be a notice of hearing notifying you as a home buyer on when the hearing is going to take place, and then both of you will appear on the hearing, and then you can argue your case, and then the decision will be rendered. So that's your Home Buyer Tribunal. And the next one, you also have the option of going to the Strata Management Act or the Strata Management Tribunal. The key here is the SMA Tribunal only hear claims which does not exceed 250,000. So the home buyer is 50,000 threshold, whereas for Strata Management Tribunal is 250,000. And similarly here, the award or the decision is to be given 60 days from the hearing. And generally, the general rule is there will be no lawyers unless you can establish that there is a very complex issue of law, or where either party will suffer financial hardship if no lawyer is involved. So usually it's being sorted out between the parties themselves without any lawyer on board. And usually Strata Management Tribunal hear various matters, but the matters must be confined to function and duty of the JMB under the Strata Management Act. So the home buyer is tied into the SPA. You can only claim for matters arising out of the SPA, whereas the Strata Management Tribunal, you can only claim for matters arising out of the Act. Under the Strata Management Act, there are certain duties that the JMB is supposed to do. So of course, the Strata Management Tribunal will have the procedure as well, which is quite similar, which is to file a statement of claim, and then the respondent will file a defense. Then you can file a reply to the defense. And after that, you can go for a hearing, and after hearing, a decision will be rendered. So in summary, I've summarized the differences between a tribunal under the HDA and tribunal under the SMA. Like I said, the amount for HDA is only 50,000, whereas for the SMA is 250,000. And only home buyer can bring a claim under the HDA tribunal, whereas under the SMA, the developer, purchaser, JMB, MC, and any other party who's interested. And the jurisdiction for HDA can only hear dispute arising from SPA, whereas for SMA, it will be any matters that arise out of the SMA. This will include, for example, defects. Of course, defects is one of it. And also example where purchasers refuse to pay sinking funds, or there's a dispute as to who is the cause of the defects. So these are matters that you can refer to the Strata Management Tribunal. Now, of course, the last option that you have is court. And in summary, court is longer. It takes longer. Usually, it may even take up to a year or two. And there's no limit as to claim amount. The court can grant different limit amount. And usually involve more complex issues or more complex defects, or where there are many parties involved. One of the example of when it comes to defects is, of course, the Highland Tower case. I'm not sure if any of you guys are familiar with it, but what happened was in 1993, there was a 12-story high apartment in the Highland Towers, and there's 3 blocks, and it was built on the hill. the elevated land. And it was built behind a very steep hill with a stream. So what happened was in 1993, there was 10 days of continuous rain. So it was raining very heavily for 10 days consecutively. And what happened was out of the 3 blocks, block 1 actually collapsed. The entire block collapsed. And then, of course, then seal off the entire project. So people who are staying in the other blocks, block 2 and block 3, they can't enter due to safety issue. And I think until today it has been abandoned. So what happened in that case was the residents in block 2 and 3 actually brought a lot of parties to court. Of course, some of the parties they brought is including engineers, developer, or the consultants as well. So these are more complex, which really requires the court to come to a finding on, who is the cause of the defects, what is the cause of the defects, who should be liable. So these are more complicated ones, which then you may want to opt to go to court. Well, of course, if it's a simpler case and the quantum that you're seeking for is not a lot, then you may want to consider the Home Buyer Tribunal or the Strata Management Tribunal. Now, so since now you know who to go after and you know how to go after the relevant party, the next question is you may want to know how long do I have to decide before I decide whether to take an action, and I know it's very common. Some of us may be fickle-minded. We always try to think. Whether we should do it, whether we should not do it. There's always a taboo against suing people. So you may want to also bear in mind that law actually fixes a time limit for a party to bring a claim. And what do I mean by that? Section 6 of the Limitation Act actually says that in the event of any breach of contract or any claim from tort, which is your negligence, you have to bring an action, you have to file a court suit, you have to bring legal proceeding within 6 years from the accrual of the cause of action. So what is accrual of cause of action? Essentially is when the breach happened, when the first time when you can sue. So in the event, with regards to defects, is when you actually found out about the defects or when the defects actually happened. Now, this is where the distinction between latent and patent defects become relevant or important, because those days, what happened is, irrespective of whether a defect is patent or latent, for example, you can find out that the defects actually happened more than 6 years ago, but you only find out on the 7th year. Under this section, you cannot sue. Because the breach actually happened 7 years ago, the defects actually happened 7 years ago, but just that you only found out recently because it's a latent defect. It's something that, there's water drip, they drip for 7 years. Then only on the 7th year, you start seeing the stain. Then only you found out, there's leakages. Then when you found, actually it has been happening for the past 7 years. But under this section, you cannot go after whoever is responsible because the 6 years for you to do so has already passed. Which may be unfair, to a purchaser because you didn't know. How do you sue? This is where the reason why the court have amended the Limitation Act. And the amendment was solely because of this issue of what we call a latent defects. Defects which you cannot discover at the time and you could only discover at a later time. So that's why the court introduced the Section 6A additional section. Essentially, I've simplified the amendments into 3 points, which is, first, you can claim anytime within the 6 years from when the breach occurred, which is the date of accrual of cause of action. But if because you couldn't find out about the defects, you only find out on the 7 or 8 years, the court actually say you still can bring an action, but you have to bring an action within 3 years from knowledge of the damage. Meaning from 3 years from when you actually discover the breach. However, there is a third point, which is in any event, you cannot bring an action after 15 years from the accrual of cause of action. What does it mean? I'm going to take you through some scenarios later to help everyone better understand what does this mean. Essentially is, no matter when the 3 years when you discover expire, you cannot bring an action after 15 years from when the damage happened. So this is the first scenario, which is, okay, say for example, you bought a house in 2000 and in 2010, you found a crack in the wall. And then there's some discussion, there's some investigation that was carried out, and it was found out that actually this crack happened in 2002, 2 years after you move in. So then the question is, how long do you have to file an action? Well, for pre-amendments, before the Limitation Act was amended, of course you have 6 years from 2002, because 2002 was when it actually happened, and 6 years from there will bring you to 2008. And since you only discovered in 2010, you cannot sue because the 6 years are already passed. But now they have amended the Limitation Act, so the timeline is actually 3 years from 2010. Because even though the 6 years had passed, you still get 3 years from when you found out about the crack to bring in action. So in this case, since you only found out in 2010, you have 3 years from 2010 to bring in action. So moving on to scenario 2. Same situation, you bought a house in the year 2000. In 2006, you found out the cracks. And then the report actually showed that the crack actually happened in 2002. So what happened? Pre-amendment, you take the year of 2002 and you take 6 years, which will end in 2008. But here, because you only found out about the defects in 2006, you actually have 3 years from 2006, which expire in 2009. So you actually get an additional year because of the fact that you only discovered the cracks slightly later. So then now you have a third scenario. Again, you bought the house in 2000, and in 2017, you discover a crack, and then the report actually showed that, look, it happened in 2002. So then the question is, how long do you have before you file an action? Now, of course, under the even post-amendment, you have 3 years from 2017, which will bring you to 2020. But remember the third caveat, which is it can never exceed 15 years from the date in which the cause of action accrued. So here, since the crack occurred in 2002, 15 years from 2002 is 2017. So 2017 is actually the final year for you to bring in action. Even though you only found out in 2017, the 3 years do not apply because of the third caveat, which is any cause of action, no matter how late you discover, cannot be filed 15 years from when the cause of action happened. Now, since we still have a bit of time, I'm going to take everyone through some interesting cases by the court in dealing with defects. The first case is the case of Tay Keng Ong and another against Yaw and Wu Developments in Berhad and others. So the question here was asked was, what happened if there's defects, they rectify it, but the defects keep occurring. There's recurrence of defects, which is quite common. What happened in this case was, home buyer purchased a house, and when they go into the house, they found out that there was a lot of defects. And the builder who built the house actually admitted to the defects, and they actually, to be fair to them, they ran a repair and they carry out the repair work, but the repair work is ineffective. The defects keep happening, it keep recurring. So the purchaser bring an action against the builder. So what the builder in that case trying to say is, look, I've already done what I can, and whatever that is happening now, the new defects that is happening now, because of the fact that it's outside the defects liability period, I'm no longer obliged to go and do it. What did the court say? The court actually said, well, that's not correct. You must address the root cause of the defects. What it means? What it means is, if you have a problem, it is not enough for the contractor to just come in and try to cover it up. For example, if you have leakages, so you can find the leakages, there's some stain on the roof. It is not sufficient for the contractor to just come in and say, okay, let me just repaint the roof, and the stain is gone. And then if there's leakages again, I'm going to go and paint it again. It's not enough for you to just come and cover it up. You must address the root cause. What is causing the patches, the leakages? You have to address the leakages itself. So this is to avoid a situation where you have cheeky contractor who are trying to do a 6:30 job, where you say, oh, there's this problem, and they try to, okay, just patch it up, just cover it, and hide all the other problems behind the walls or on top of the ceilings. So the court actually said, no, that is not enough. You have to find out what actually caused that, and you have to go to the root cause, and you have to solve that problem. Which I think is fair, because then as a home purchaser, you are assured that the defects will be attended to. Therefore, even in the event of recurring defects, if you can show that it is caused by the same problem, you can still claim against the builder. Now, the second case that I would like to discuss is the case of Krishnantini Angela Regina against Bill Esteems and Nirvan Bhatt. So what happened here was there was a defect to the unit. The purchaser tried to sue the developer for cost to rectify the defects. But the problem here is the purchaser did not comply with the process under the SPA. As I've taken you through earlier, there is a process, an agreed process in which you must notify the developer of the defects, and then the developer will have 30 days to go to rectify it. If they don't, then you have to notify them of the cost to rectify. And if again another 30 days they don't do it, then only you can find someone else to come in and do it. So in this case, the purchaser didn't do that. I think what happened was the purchaser just went ahead and appoint someone and they went and do it, and they tried to claim against the purchaser, against the developer for the cost. So the developer is trying to argue, look, because you didn't comply with the clause in the sales and purchase agreement, you cannot claim. So what did the court found? In a simple way, the court said, no, that's not the right way. What the court found is clause 29, which is a DLP clause, is an additional right to purchaser to sue. It does not limit or bar the purchaser. Just because the purchaser do not follow the procedure under clause 29 to claim against the developer, this doesn't mean the purchaser loses its right to claim altogether. The purchaser actually still have what you call a common law right to sue the developer. Now, this case is an interesting case because it deals with patent defects, meaning defects that was discovered during the DLP, but only just because they didn't comply, the purchaser did not comply with the procedure to give notice, the developer is trying to shun away from the obligation to do so. But it'll be interesting to see what happens in the event of latent defects, or even defects that appear after DLP. Does it extend to that? Does the principle in this case extend to even defects, whether latent or patent, that appear after DLP, whereby a home buyer can say, well, even though this defects is patent defects, even though it appear after DLP, I can still go after the developer because according to this case, there is still a common law obligation for you to rectify it. So that would be interesting to find out. Now, moving on to the final case, which is Sandy Island Pte Limited against Teo King Tay. As you will see from the name itself, this is a Singaporean case. And what happened here was, again, similar. Purchaser bought a house from developer, and after taking possession of the house, purchaser found defects. And they found defects, and what happened? The parties actually carry out joint inspection. What happened was the developer requests for access to the unit to investigate the defects and establish the cause. But the purchaser here, for some reason, refused, to grant the developer the permission to go into the house or to rectify, because the purchaser here thinks that the developer's proposed method of rectification is not correct, it's insufficient. So what happened was the purchaser didn't let the developer to come in. The purchaser actually went ahead and get their own contractor to rectify it. So then the issue that arises here is, of course, as the developer will say, look, I have all along been willing to go and rectify, but they didn't allow me to. Is it now fair that the purchaser be allowed to claim against me? So what did the court held? The court held that, well, okay, I agree with you, Mr. Developer, that it's not fair that they don't allow you, but this doesn't mean that you're not responsible at all, because it's not disputed that there was defects, and the defects is caused by you. So that's that you are still liable for any cause, but the very act of the purchaser of not allowing the developer to go in to rectify may affect the quantum of the damages in which the purchaser can claim against you. Why do I say that? Because in the event as a purchaser, you allow the developer to come in to rectify the defects, arguably the developer will be doing it for free. they're going to do, the developer is going to get their own contractor and they're going to do it at the developer cost. But because of the fact that you as a purchaser, you have rejected, you have refused, and you got someone in to come and do it instead, then this might affect the amount of damages you can claim. So for example, for whatever reason, you get someone who is really expensive because on the assumption that, oh, I can claim against the developer, so let me get like the top-notch contractor to come in to rectify. But you must be careful if you have actually denied the developer opportunity to rectify your defects, you may not be able to claim the full amount which you have incurred. So that was one of the interesting cases that that you as purchaser or even as developer that you may want to bear in mind. So I think with that, that's all we have for today. This is just a bit of background about myself. For those of you who do not already know, I'm a lawyer who specializes in construction. Please feel free to follow my firm's social media. And if you have any question, I'm sure some of you would have already, feel free to ask. Once again, I'd just like to thank Excel Academy for having me. And yeah, I think I'll pass it back to Nelfa.
All right. Thank you, Mr. Leong. I believe now we have a better understanding of the differences between latent and patent defects, as well as who is liable for them. Now we'll move on to the Q&A segment, where Mr. Leong will hopefully clarify any questions we have on today's topic. Right. So for our first question, we have a question from Ms. Shikin Shahrul. What are some of the key reasons why project risks go unidentified or unaddressed?
Wow. I mean, I think the answer to this question can, to answer this can take up days because it's such a wide question. Of course, there are many factors. One is competence of people who are involved, the relevant stakeholders, be it contractors, be it homeowners, be it developers, with competent players. Of course, there will be lower risk, or at the very least, risks are more identifiable and easier to be addressed. And two, I would also say is because of the lack of knowledge, which is why it's good initiative for Excel Academy to have all these initiatives so that we educate, or at least people is aware of what are the risks. And in buying a house or in developing a project, at least you're aware of all the potential pitfalls that you should avoid. So there are many factors, and these are just two that I can think of at the moment.
Super. All right, so moving on, we have another question from Ms. Miza D. What are the obligations of the contractor during defect liability period?
Well, like I mentioned, during defect liability period, any defects that arose during this period, the contractor actually had to rectify. And I've mentioned during one of the case study, it is not sufficient for you to just address the face value of the defects. You have to go into the root cause. So you need to identify. So even some contractor trying to be cheeky and try to rectify so that the next time if another new defect come out is actually beyond the defects liability period, this doesn't mean that you as a contractor you're not liable. You still have to address it if it can be found that it is actually caused by the same problem which you have failed to rectify during the defects liability period.
I see. All right, thank you, sir. We have another question from Mr. Nicholas Chong, and I believe this will be the last question we have for today. Is the seller obligated to disclose latent defects?
That's an interesting question. First of all, the very nature of latent defects is not discoverable. But if as a seller, you know that there's a latent defects, of course you have to tell it to the buyer. Otherwise, it will amount to fraud or even misrepresentation. Because as a seller, you need to make sure that whatever products you're selling, it is fit for its purpose. So the fact that if you're aware of latent defects, first of all, you're supposed to rectify it. And even if you don't rectify it and you choose to sell it to the buyer, actually you have a duty, I would say, to let them know that there's this problem. So the short answer to the question is yes. Yeah, you have to disclose. Otherwise, you run a very high risk because, and as I said, you are liable for latent defects anyway under the law.
All right. I hope that answered your question, Mr. Nicholas. We have now reached the end of this talk show. With that, I would like to take this opportunity to invite all of you to our upcoming CPD seminars, uh, which will be held in March. So first off, we have the Digital Marketing Masterclass on the 7th and 8th of March. And after that, we'll be having the Residential Tenancy Act Issues and Challenges CPD seminar on the 18th of March. And lastly, we have the Key Principles of Contract Law and Agency Law for Real Estate Professionals on the 25th of March. So if you are interested to join any of these seminars, feel free to go to visit our Facebook page, which is the Excel Academy of Real Estate Facebook page, as well as contact any of the sales rep down below, including myself. I'm Naufa. Once again, I would like to thank Mr. Leong for sharing his insights on today's topic, as well as all of our participants for tuning in today. Uh, Thank you. Thank you so much. We hope to see
Thank
you
you.
in the next one.
Thank you, Nova. Thanks everyone. See you guys.